So nice to meet you. Thank you very much. So nice to meet you. Thank you.
Can we have the formal appearances of the parties, please?
Good evening, members of the tribunal. My name is Farah Nabila, and this is my co-counsel, Mr. Revaldi Wirabuana. We're representing Reliable Holdings Incorporated, the claimant in the present dispute.
Thank you, Ms. Nagara?
Farah Nabila.
Pardon?
Farah Nabila Ruga.
So, what name do I use to address you?
Farah would be
Farah, yes. Very well, thank you.
Good evening, dear arbitrators. My name is Anna Petrova. I appear alongside my colleague Tom Dobstad. We represent Super Charters, the respondent in these proceedings.
Thank you, Ms. Petrova. Now, have you worked out between you how you're going to run the procedural side of the case and who's going to do what?
Both parties have agreed that the respondent will raise their procedural claim first. It will be responded by the claimant, and then the respondent will have a rejoinder with regard to procedural claims. It will be followed and continued by both counsel for the claimant on the substantive claims, and will be continued by both counsel for the respondent, and then we reserve 2 minutes for rebuttal.
And how have you divided up the time for the procedural points, and how much time is each of you as speakers going to take on those, so that the timekeepers know? And
the respondent will first speak for 13 minutes. The claimant will then speak for 8 minutes. The rejoinder will be 1 minute, and then the claimant will speak for another 6 minutes. The second counsel for the claimant will speak for 14 minutes, and then
I will continue by speaking for 16 minutes.
And then we will have a rebuttal for 2 minutes.
okay, so that there's going to be one counsel. I take it, Ms. Petrova, it'll be you on the procedural point for 13 minutes.
Correct.
13.
13, yes. And then who will speak on your side for the procedural? 8 minutes. Which one of you is going to do that? You'll do that. Okay. And then the rejoinder you'll do, Ms. Petrova. And then 1 minute. So on the procedural one then, as we understand it, you've agreed 13 minutes for Ms. Petrova, 8 minutes for Farah, and 1 minute in rebuttal for Ms. Petrova. And then the substantive points, are you, Farah, going to spend 6 minutes to begin with on those, and then Mr. Nabrana.
It's Mr. Negrana, is it?
Wirabuana.
Wirabuana.
You're going to spend 14 minutes on the substantive point, and then Mr. Dobstad, you're going to spend 16 minutes responding, and who's going to do the rebuttal?
I'll be delivering the
You'll do the rebuttal. So, yes, that's clear. And are there any other procedural matters that we need to clear up before we start the meet?
Not on the side of the respondent.
Yes. Well, Ms. Petrova, would you like to start with?
Mr. Arbitrators, Madam Arbitrator, good evening. In the upcoming 13 minutes, I will present the procedural arguments on behalf of Super Charters. At first, I should establish why we're here today. We are here today because reliable tankers spectacularly failed to fulfill their contractual obligations. Not only did they do that, they also neglected to fulfill the procedural requirements for commencement of arbitration. And now they don't want to live up to the consequences of their mistakes. In light of that, and on behalf of my client, I would make two submissions. The first submission is that reliable tankers' first reference is a nullity and does not validly commence arbitration. This submission is followed by my second submission, that counterclaims by reliable holdings with respect to Supercharter's second reference are time-barred. If I may proceed to my first submission, I would kindly invite you to read with me page 113 of the case file.
Yes, that's the expert report. We've read that.
I would like to draw your attention to paragraph 3, the second sentence. And if I may read it for you. Where this occurs, that is a merger by universal succession, there is one single surviving entity which can be elected by the participants. What has happened in the present case is that Reliable Tankers has merged with Reliable Holdings, and the surviving entity has been chosen to be Reliable Holdings. Why is this problematic for our case? A notice for commencement of arbitration proceedings was sent in the name of Reliable Tankers, which, at the time the notice was sent, was a non-existing entity.
Why wouldn't this just be like a scheme of arrangement where the companies just merge and one can exercise the rights of the other, and this is just a procedural matter of no substance?
The problem in the present case is that the merger occurred before arbitration was commenced. This raises policy reasons on the enforceability of awards with regards to the arbitration.
I think we understand that. The question is, why wouldn't we just treat this as being something that is of no moment, because in substance the rights that Reliable Holdings has are the rights of what was Reliable Tankers and can proceed in its name.
Mr. Arbitrator, case law distinguishes two fundamental types of mistakes: mistakes of name and mistakes of identity. The former, mistakes of the name, can be corrected by the tribunal. However, when we speak about mistakes of identity, that cannot be corrected.
What's there to indicate that it's in the second class rather than the first?
Pardon?
What's there to indicate that it's a mistake of the name, an identity rather than name?
Thank you for your question. I would like to refer you to tab B of the dark grey folder. This is a case from the Court of Appeal from 2005, AMB Generali Holding. And on page 15, paragraph 51, you would see the relevant test that has been established by the court. Now, this is in relation to arbitral proceedings. If I may, in essence, summarize the case, it is how supercharters would have perceived the notice for commencement. That is, whether they could have reasonably identified Reliable Holdings to be the entity commencing proceedings. If beyond reasonable doubt supercharters could identify Reliable Holdings to be the entity commencing arbitration, then the conclusion would be that this is a mistake of name and it can be corrected.
Is it not the case that the recipient of the notice at page 101 would have understood it to be a notice served by the owners of the vessel, which was the subject of the Charter Party?
Mr. Arbitrator, so far communication has been with reliable tankers, and supercharters were unaware at the time they received the notice for commencement that a merger has occurred. At the time, they could not reasonably identify the owners to be reliable holdings.
Now you relied on this case from the SEB case.
Correct.
And in the judgment of Lord Justice Buxton, he's referred to other cases as well. What is the test now? Has Lord Justice Buxton introduced a subjective test?
Lord Justice Buxton has introduced that test, which is rather subjective. However, the test is also limited by reasonableness.
Well, that makes it objective.
Indeed, however, the most essential thing is how the party to whom the notice was addressed
Would reasonably have understood. In other words, a reasonable
Correct.
person in your client's position would have known that this was being commenced, wouldn't it, by the owner?
Mr. Arbitrator, that is contested by supercharters. The only evidence of a merger
So
is
the subjective test will assist your client.
correct.
So can you explain how you apply the subjective test to the facts?
Yes, Madam Arbitrator. Supercharters were not aware that a merger has occurred. There was one press release on page 100 that is named Shipping Whispers. Further in that entry, it is stated, and I quote the last 2 lines, "It appears that the people behind Reliable have tried to keep it out of the news." Supercharters' statement is that they could not have known that a merger has occurred.
Well, do we know when the timelines for all that occurred as to when the arbitration was started by tankers and when the news of this broke?
The newspaper entry is from the 3rd of January, and arbitration, or the notice for commencement, was sent on the 28th of January.
So the news was out almost 4 weeks before you got the notice. So why wouldn't you have known?
If I may draw your attention to the 2nd paragraph, which consists of 1 line in the notice for commencement on page 101. It reads, "A copy of the Charter Party is appended to this notice." So far as the Charter Party is concerned, and I'm reading page 4 of the case facts just for illustration, it states that the owners are Reliable Tankers Incorporated.
And all their rights have now passed to holdings.
That would have been the case.
So why isn't what Lord Justice Buxton said at paragraph 54 the relevant test here?
The relevant test, again reiterated in paragraph 54, is that there should be no possible doubt that the notice was sent on behalf of Reliable Holdings.
Or who else could have sent it?
It is Supercharter's submission that from the notice they can only conclude that it was sent on behalf of Reliable Tankers.
What would have been the purpose of the notice served on behalf of Reliable Tankers?
On page 104 of the case, Reliable Holdings explain why they named Reliable Tankers to be the entity commencing proceedings. And they state that they thought that that was the current name of the contractual counterparty under the Charter.
So it was a slip.
This shows that they deliberately put Reliable Tankers to be the entity on top of the notice for commencement.
And they made a mistake, did they not?
they made a mistake, however, the character of the mistake is important, whether that was a mistake of name or identity.
Well, there wasn't at that time, according to your argument, any entity called Reliable Tankers, so it could only have been a mistake, couldn't it?
It is not disputed that there has been a mistake. The disputed fact is that there has been a mistake of identity, and that arbitration was started in the identity of Reliable Tankers.
Well, I suppose we better move on with your time to the second point of appointment.
Thank you. Mr. Arbitrator, the second submission is that counterclaims by Reliable Holdings with respect to Supercharter's second reference are time-barred. It is an established principle that a contractual time bar is an absolute time bar for claims. Not only does it bar a claim, but it also bars the remedy of arbitration. It also embodies the principle of party autonomy, and as such, a contractual time bar should be upheld. It is Supercharter's submission that the contractual time bar incorporated by Supercharter's standard terms of business would have expired and as such, Reliable Holdings would not be able to make a counterclaim.
What date do you say the time bar would have expired? The actual date?
Delivery should have happened on the 10th of January, and with 20 days time bar, that would have been the 30th of January.
So this argument stands or falls with your first argument, because if the notice of the 28th of January was valid, then they were within time.
That is correct. It is Supercharter's submission in that respect that has the tribunal, if the tribunal upholds that Reliable Tankers' first reference is a nullity and does not validly commence arbitration, then Reliable Holdings will indeed be time-barred to submit counterclaims under the second reference. In view of my time, I would like to briefly conclude and kindly invite the tribunal to hold the first reference by Reliable Tankers to be a nullity and declare that counterclaims by Reliable Holdings would be time-barred. Thank you.
Thank you, Mr. Turner. Yes, Ms. Farrow.
Members of the tribunal, for the next 8 minutes, I will be delivering our submission that Reliable Holdings Incorporated is entitled to submit claims before this tribunal. Members of the tribunal's Reliable Holdings Incorporated has lodged a proper notice of appointment in order to commence the arbitration on 28 January 2012, which unfortunately was regarded as invalid by the respondent based on 2 reasons. First, because we used the name of RTI, which is an administrative error and it should be a nullity, and second, that we are time barred. Now I will address those points in turn. On our first point, they have alleged that this proceeding must amount to nullity because we used the name of a non-existent party. Earlier, Mr. President Browers was concerned about why this is a significant issue, and the answer could be found in tab 4 of our bundles of authorities. It is the light gray one, which is the case of AMB versus Maastricht decided in 2006 before the Court of Appeal. Now in the orange correct part, we have highlighted the relevant part of the judgment, which stated that if the proceedings were started on behalf of a non-existent party, then a proceeding would amount to a nullity. But if such mistake, error in using the name of a non-existent party was found to be a misnomer, then it can be corrected simply by amending the name of the party. Now it is our submission that our error in using the name of RTI was a case of misnomer that can be simply corrected. Earlier, the respondent has argued that the relevant test of misnomer itself can be found in this very judgment, AMB versus Maastricht, that is, who would reasonably understood by the other party as to the identity of the party bringing the claim. And we note that the respondent has also distinguished the 2 kinds of mistakes, namely the mistake of name and mistake of the identity. And therefore, we submit that the question relevant before the court was not whether the respondent aware about the occurrence of merger, or whether the respondent aware that it is Reliable Holdings Incorporated or Reliable Tankers Incorporated, but rather whether the respondent aware that we submit this claim as the owner of Reliable Butterfly, which is the identity of our side.
Well, on the other hand, you knew all the facts at the time you commenced the proceedings, and you chose deliberately to suppress the non-existence at the time the proceedings were commenced of Reliable Tankers, which you knew had no longer existed. Now, why didn't you refer at all to the status of your client in her notice?
Mr. President, in line with our claim submission, as can be found in page 104, this is a mere administrative error in our site, which was also explained in our second notice of appointment in page 104, where we have stated that we used the name of RTI because we thought it was the current name of the contractual counterparty of the respondent. And it is indeed our intention not to confuse the respondent as to the identity of our site. And here, Mr. President, we submit that our error in using...
It tends to suggest that this was quite deliberate on your side, that you chose to use a non-existent entity's name, knowing it didn't exist, without revealing the background facts that were known to you, but not apparently, so it said, to the other side.
It may be deliberate, Mr. President. However, as established in the case of AMB versus Maastricht, the tacit misnomer in an arbitration proceeding was based on one sole factor, namely whether the other party understood about the identity of the party bringing the claim.
Well, what I can't understand, Ms. Farah, is that if something is done deliberately, how can it be a mistake?
It is an administrative error in our site, which we thought that Reliable Holdings Incorporated at that time still regard the contractual counterparty as Reliable Tankers Incorporated. But members of the tribunal will submit that in the current proceeding we have made a clear understanding on our
May I
identity.
ask you a question? Based on the doctrine of succession, who would be the owner of the vessel at the time of the commencement of the arbitration?
That would be Reliable Holdings Incorporated now. And it is our submission that because we use the name of Reliable Tankers Incorporated does not necessarily mean that this proceeding must amount to nullity. And further, we have for the
because
sake of...
the action is brought by the owner, is that what you're saying?
Yes, that
the
is
proceedings are brought by the owner
by the owner of Reliable,
of Reliable
Butterfly.
Thank you.
In our first notice of appointment, we have referred ourselves as the owner of Reliable Butterfly and attached a copy of our charter party, which was concluded by the respondent and the claimant. And therefore, there was no possibility for the respondent to have a genuine misapprehension as to our identity as their contractual counterpart at the time. And therefore, we submit that this is not a case of misnomer, and as a consequence, this mistake can be corrected by amending the name of Reliable Tankers Incorporated to Reliable Holdings Incorporated.
Although you better just move on to the time bar issue, given your time.
Certainly, Mr. President. Now, having established that this is a case of misnomer, we submit that we have commenced the arbitration pursuant to Clause 4 of the Charter Standard Terms, where there exists a time bar limitation provision. Now, under that provision, as has been argued by the respondent, we have to commence an arbitration within 20 days after the discharge would have taken place. We do note that there is no dispute on when the discharge would have taken place, that is on 10 January 2012. And since our first notice of appointment on 28 January 2012 provided in page 101 of the records is sufficient, we submit that we have conducted the proceeding in timely manner pursuant to the time bar limitation provision. Mr. President, members of the tribunals, I believe that I have responded to all
what if you were wrong about that first point, about the misnomer?
About the misnomer part?
Yes, so that notice on the 28th of January isn't a valid commencement of arbitration.
If this is not a case of misnomer, then we concede to the fact that this may in turn that these may in turn as a consequence help us to be time barred from submitting any claims before this tribunal. But we do believe that our first point, that it is a case of misnomer, would stand, and therefore it is our submission that we have commenced the proceeding in timely manner.
So it's a do or die question. Is it? You're either started the proceedings correctly or you have no claim at all.
You
Yes.
accept the second notice as time barred, is that what you're saying?
Yes, that is our contention. That concludes my submission.
Thank you, Mr. Farrar. Yes, Ms. Petrova. Anything in reply?
Mr. Arbitrator, Madam Arbitrator, having heard the submissions of my learned friend, I do not consider it necessary to rebut.
Well, we can now reserve our decision on that and proceed to the question of the substance. Ms. Farrar.
Members of the tribunal, for the remaining 6 minutes, I will address our contention that Reliable Holdings Incorporated is entitled to freight. As evident in page 8 of our fixture recap, both parties have agreed to incorporate both parties' standard terms. Now, our standard terms, as can be found in page 44 of the records, suggested that under clause 4, there exists an advance freight clause, which, if I may read it to the tribunal, it states that freight deemed earned in full, discountless, non-returnable, and 95% of minimum freight payable upon lifting subjects. Now, we do understand that there exists a general freight clause under Asbatang Boy Charter Party that can be found in page 11 of our fixture recap of the Asbatang Boy Charter Party. In page 11, specifically in clause 2, there exists a general freight clause, which in the second line suggested that freight could only be payable upon delivery of cargo at the destination. So the question before the tribunal is which freight clause provision should prevail. Now, to answer this, we would like to invite the tribunal to open tab 5 of our bundles of authorities, which is the case of the Karen Baptist, decided in 1988 before the House of Lords. Now, in the orange flagged part, it is in tab 5.
Yes.
In the orange flagged part, the highlighted part suggested that freight generally would be paid upon delivery of the cargo at the destination. However, when there exists an advance freight clause, as agreed by both parties, it can be used as an exclusion, and it means that the advance freight clause that had been agreed would overrule the general freight clause contained under pre-printed forms such as Asbatang Boy Charter Party. So there's no questions left unanswered before this tribunal with regard to which clause should prevail, because our advance freight clause would prevail at this moment. Now, we submit that we have full entitlement to the freight, as our freight clause in page 44 suggested that we have the right to freight upon the lifting of subject, which is the precondition for the freight to be deemed earned. Now, since still in the judgment of the Karen Vatis, in the blue flagged part, it laid down an example on how to interpret an advance freight clause, which had been deemed earned upon a certain condition, where in that case, the certain condition was the time when the cargo loaded. However, in the present dispute, it provides a rather different test, or a precondition requirement, namely that the freight would be deemed earned upon the lifting of subjects. And in the present dispute, as can be found in both parties' claim submission, both parties have agreed that the lifting of subject would occur on 19 November 2012.
Well, that's on page 47 at the top of the recap. That's on page 47 at the top of the recap.
The lifting of subjects?
Yes.
But it is contained in both parties' claim submission, where
It's in the contract.
Hmm?
It's in the contract, on page 47.
Oh, which is our advance freight clause. Now, if I may come back to my submission, we submit that since the precondition for the freight to be deemed earned had already acquired, we have full entitlement to the amount of freights that we claim to be payable by the respondent. Now, it is our submission that despite the cancellation of the charter party on 27 November 2012, our right was not defeated. It is because in the case of the Dominic, as can be found in tab 6 of our Guidelines of Authorities, which was decided in 1989 before the House of Lords, in the orange flagged part, it was stated that if a condition upon the freight to be deemed earned had already occurred, then the owner would have full entitlement to such amount of freight, and it would not be defeated by the occurrence of cancellation, be it by means of repudiation or general breach of the charter party.
Do you say this principle avails you, even if once subjects have been lifted, the owners simply sailed their vessel off into the sunset and never went anywhere near the load port?
Members of the tribunal, it is our submission that once the lifting of subject had occurred, we have full entitlement to the freight. However, it is our submission that we have performed a portion of our obligation under the charter party, namely to commence our voyage to the load port, which was also scheduled as our itinerary, as can be found in page 4 of the fixture recap, which will be later delivered and explained by my colleagues.
Why doesn't your without recourse clause deprive you of this? Why doesn't your without recourse clause in clause 4 deprive you of this argument?
Members, Mr. President, the without recourse clause contained under our standard terms only discharge further liabilities and rights pertaining to the cancellation of the charter party, but it did not in any way defeat the right that we had already accrued before such cancellation. It will be addressed further by my co-counsel.
Time is up.
Thank you, sir.
Thank you, Ms. Farrow. Yes, Mr. Bjorna. Sorry.
Mr. President, members of tribunal, I will address two further claims for the claimant. First, that the contract has been cancelled without recourse. It can be found under submission 3 of our outline. Second, we will also submit that in any event we did not breach charter party. This will be submission 4 in our outline. And I will also be addressing the recoverability of the items of damages, which is submission 5. Now, with regards to our first claim, it is our contention that the contract has been cancelled by operation of clause 2 of reliable tanker standard terms, which is the cancellation clause in the present case. If I may direct you to page 44 of the records, clause 2, the cancellation clause, reads, and if I may read it for the tribunal's convenience, if it becomes evident that ship will miss her cancelling date, owner to give a new ETA and laycap. If charterer elects to decline, the charter party to be cancelled without recourse. We would like to note that the wording to either party whatsoever has been deleted as per request of the charterer in page 3 of the records that we have duly provided in our final offer dated 17 November. We would like to note that this is the final offer that was accepted and therefore the clause should be amended accordingly. However, we would like to take this tribunal's attention to the meaning of the word without recourse. Without recourse would mean that both parties will be released from further obligations and liabilities because it no longer gives the right for a party to approach a court or a tribunal to ask for certain legal demands such as compensation or loss and damages. This is the effect that was held in the case of Smith International versus Joseph Mobius, a case before the Commercial Court in 2001. Therefore, we submit that in the present case, if the clause is used, then parties can no longer bring claims arising after the cancellation, since both parties has been released from further obligations and liabilities. It is our submission that in the present case, the clause has validly taken effect. If I may direct you to page 95.
Well, just before you go there, what meaning do we get out of the preceding part of the clause. If Charter elects to confirm, then Charter Party remains in full effect with new lay canon. Don't we take the reading of this as a whole, as sensible business people would take it, and say, well, if you can't lift the cargo, that's the end of it, and you can't get 95% of your freight. That would be a nonsense. You say you're going to miss the cargo, and they've got a right to cancel the charter, but they still have to pay 95% of the freight for you doing nothing. Doesn't sound like a commercially sensible arrangement to me.
Members of Tribunal, we submit that in the present case, even though it might seem unusual, however, this is what the parties have agreed, and the fact...
But why do you say they've agreed? You're saying we've got to read the clause in this way. It produces an absurd result. The cases also say if you don't read a clause, if you can read a clause not to produce an absurd result, you do that rather than this. And as Justice Fock was saying, your clause seems to say you don't have to. You can turn the ship away and not fulfil the charter at all, and earn 95% of the freight. Well, why would you read this without recourse in this way, where you are saying we can't meet the terms of the charter party, and they've got a right to cancel?
Members of Tribunal, we submit that in many cases, for example, in
Before you answer the question, you might as well consider this point. You have relied on the Dominic, and I believe Lord Mustle has also referred to a concept of total failure of consideration. You might want to deal with that point together with the President's question.
Firstly, to deal with Ms. Ang's question, we would submit that in the present case there is no total failure of consideration because the parties have agreed that the duty that the ship owner should do in order to earn the freight is merely after the lifting of subjects. However, we still have performed part of our duties according to the charter party. Further to answer to Mr. Rare's question, we would submit that in a lot of cases, judges have held that a clause containing a without recourse provision is a fair allocation of risk. For example, Judge Morrison, in the case of Smith International versus Joseph Mobius, decided that even though a without any recourse provision is considered to be crude.
What is the meaning of lifting of subs?
Lifting of subjects is the condition where all the subjects to the contract have
So
been...
it only creates the contract, right? It doesn't deal with commencement of the voyage.
Yes, however, that is what has already been agreed by both parties as the condition that is necessary for our client to receive the freight.
You mentioned just now that your clients had done everything that they were required to do to earn this. Tell us what they actually did.
That will be submission 4 of my discussion. If you want me to deal with that first, or would you like rather?
At your convenience.
Okay. If I may then first address the contention made by the respondent before I get to your concern, Mr. Fogg. The respondent would later submit that they have exercised both right to cancellation and repudiation at the same time by way of their notice of cancellation dated at 27 November 2011. We would submit that that is not the case because the notice of cancellation in that page, in page 96 of the record, clearly uses the words that is contained in the cancellation clause. It is a well-established principle that in the case of a repudiation, which might be later alleged by the respondent, the other party, the injured party, must clearly accept the act as repudiation to terminate the contract. However, if I may direct this tribunal to tab 10 of the bundle of authority. In the page that we have flagged in yellow, we have highlighted 2 paragraphs that this tribunal should take their attention to. The first one is the one that is on the bottom part of the left column, which stated that if a contract and a general law provides the injured party with alternative rights and have different consequences, then he will necessarily have to elect between them, and the precise term in which he informs will be significant. And in the earlier highlighted part, it is stated that if a notice makes explicit reference to a particular contractual clause and nothing else, this may in context show that the giver of notice was not intending to accept repudiation, but rather only seeking to rely on a contractual clause. And in accordance to page 96 of the record, which is the notice of cancellation, you may find in the second paragraph Super Charter statement that in the premises we treat your letter as providing a revised ETA and Leung for undetermined dates. This is a clear using of the word contained in the cancellation clause, since both deal with a revision of ETA. And in the third paragraph, in the first sentence they choose not to accept, and in the last sentence they choose to still decline to whatever dates that we would have proposed. This is also a clear usage of the wordings that is contained in the cancellation clause. We therefore submit that in the present case,
Well, the next paragraph contradicts that. They say they've got rights. If they're doing it under the cancellation clause, they don't, according to you. Unless these are accrued rights before they cancel. Why aren't they accrued rights? You've given them invalid.
in respect of the
ETA.
notice, the tribunal should take a look at the wordings that they use to bring the contract to an end. And the wording that they use in that respect is the wording in the cancellation clause. As earlier submitted, the respondent is trying to submit that this notice would suffice for both cancellation and repudiation, but we in return submit that this is clearly a cancellation by way of a cancellation clause. Members of tribunal, having established that, we would then turn to our second submission, or that in any event, our client did not breach the charter party. The main contention in today's proceeding is the arrest that happened in Red Tent Bunker Port. We would submit that even in that arrest, we have proceeded with convenient dispatch as obliged by the charter party. Respondent might later turn the tribunal's attention to clause 1 of the Asbatang for a charter party contained in page 11 of the records, which provides that the owner should proceed with all convenient dispatch to the loading port. However, we would submit that the definition of convenient dispatch is provided in cases such as, for example, Hick versus Raymond and Ray, which stated that we must also take into account the circumstances that exist during the time the delay occurs to establish whether the delay was reasonable. So as long...
Don't we look at clause 19 in the boilerplate terms and the requirement that the seizure under legal process provided bond is promptly furnished, released vessel or cargo as part of the construction of clause 1? You read the contract as a whole, so how do you deal with that? Where's your convenient dispatch when you don't pay the money to get the release?
We would submit that the reason we cannot afford security during the arrest was due to two unforeseen intervening circumstances that was unforeseeable. The first one is the fact that the bunker suppliers has put forward a preposterously high figure that we cannot afford. And the lack of liquidity in our client's part was mostly caused by the second intervening circumstances, which is the fact that the respondent has never paid for the accrued right of freight. We would submit that in that unforeseeable circumstances, it is reasonable for us to first try to directly negotiate with the bunker suppliers for a more sensible figure that we could have afford and provide security for. And second, we would submit that our decision not to contact the P&I club should also be deemed as reasonable, since our P&I club, which is called P&I, does not cover arrest due to unpaid bunkers. If I may direct you to tab 23 of our bundle of authorities. This is the P&I rules of SCULP in 2011, and we note that SCULP is the P&I provider of our client. In the blue flag part, which I believe is the first page, it is provided that a letter of undertaking by SCULP will be provided if the reason of the arrest is coverable. And if you take a look at the yellow flag page on the document, which is the P&I cover, through point 5 to point 26, there is no provisions regarding unpaid bunkers. We therefore submit that in that case, we are not protected by the P&I club, and our only hope to release the vessel is to have negotiations directly with the bunker suppliers. We therefore submit that our actions is reasonable and we have proceeded with convenient dispatch, at least until the date where the respondent chose to cancel the contract without recourse. However, members of tribunal, in any event, we would like to submit that the items of damage claimed by supercharters are not recoverable. The test of damages, of foreseeable damages, if I may emphasize, is elaborated in the case of the Achilles, a case before the House of Lords in 2008. It was held that first, loss arising out of unusual volatility in the market is not recoverable since it is not within the contemplation of reasonable men. And second, it was provided that a result of negotiation with third parties is not within the contemplation because we cannot predict the action of those parties, let alone any forms of quantification that might arise out of those actions. In the premises, we submit that the first item of damage claimed, which is the cost of chartering a more expensive replacement vessel, is a result of an unusual volatility in the market, as can be seen in page 99. And in the second and third items, which is claims under settlement costs with buyers and sellers at the ports, are caused by negotiation with third parties that we know nothing about, and therefore we submit that we cannot arrive on the quantification on a proper contemplation. We conclude. Thank you.
We'll give you 2 more minutes to finish because we've asked you a few questions, if you wish, and we'll add that to you, Mr. Dobbs.
I have finished with my submission unless there are questions.
Have you? All right. Well then, we don't need to give you 2 minutes for you. Yes, Mr. Dobbs.
Thank you very much, Honourable Tribunal. But before I go into the substance of that case, please allow me to clarify what my learned friend has just claimed. In essence, he has claimed that both parties entered into a contract which is commercially hardly sensible, and as you have just put it yourself, Mr. Chairperson, it is nonsense, or it leads to nonsense. No, not having paid for bunker, and this is why the ship was arrested, and then not having released that ship from arrest does not entitle a person to almost $5 million. This is morally wrong. In the next 16 minutes...
Wasn't the answer to that point what Mr. Werner said, that you didn't pay the freight, the 95% of the freight, so if they'd had that, they could have easily met the bunker claim, got the ship released, put up the security, and you wouldn't be here.
Mr. Chairperson, the first question to that is that my client submits that the charter party prevailed over the standard terms. There is no indication in the standard terms that it overrides the charter party. And it has not been, at least that clause, specifically negotiated upon. Secondly, payment.
When you say it wasn't specifically negotiated, you've got a specific term in the recap that says both parties' standard terms are incorporated in full. It sounds like you negotiated that pretty clearly.
And what's more, clause 2 contained words that your client objected to, and you negotiated for their deletion.
In response to both of your questions, the amendment my client asked for relates to clause 2, not clause 4. Yes. And secondly, only to incorporate standard terms doesn't mean that they override the actual contract. It is part of the bargain, it is part of the contractual relationship, but it's subsidiary to the contract itself. There has been no authority cited by my learned friend that this is otherwise. One additional thing I'd like to mention is that my client, were their submission be followed, should have paid when subjects were lifted on the 19th of November. Now, it was only on the 28th of November that they reminded my client of the outstanding claim.
Well, you were lucky, weren't you, that you got reminded?
I don't consider
Your
my
duty to
client.
pay.
I don't consider my client to be lucky if since there's been no ship provided. Yet, even if we were lucky and we would not succeed in the first submission, the second is that my client claims freight as damage. Now, for that, I'd first like to establish that indeed Supercharter's notice of cancellation terminated the contract under both common law and the contract. My learned friend has already tried to enlighten you on that law, but I'd like to take that a bit further. First of all, I rely now again on the same case as my learned friend has, and this is Shell Egypt, and I'd also like to refer to the same page, 13.
Which tab was it?
This is tab red 10 of their bundle, so the bright grey one. Sorry, there are so many colors in that.
Yes,
case.
yes. Yes. So it's...
And rather than reading that case, or just some statements in isolation, I'd like to have them holistically. Are you all on that page? No? Yeah, okay. Now, on the left, on the right page, so page 13, left column, it says in the very bottom, it must be borne in mind that all that is required for acceptance of repudiation at common law is for the injured party to communicate clearly and unequivocally his intention to treat the contract as discharged. In addition, in Latvian shipping, it was said by Lord Briggs that no reasons need to be given. Now, this is the general rule, and now the exception applies, or has been said by my learned friend to apply, that where there are inconsistent remedies, inconsistent legal consequences of those two rights, that election has to be made. So the question before the tribunal is, are those rights inconsistent? And the submission is, they are not. They are not because the case which has been referred to in Shell Egypt is the case of Dalkia Utility. Now, the case of Dalkia Utility and Shell, there, the right under common law had entitled party A to a manufacturing plant, while the contractual right would entitle party B to that. So there's a clear inconsistency. Under one right, party A is entitled to the property, while under the other right, party B. Now, this is clearly inconsistent. Nothing of that kind is present in our case. Also in Shell Egypt itself, the notice of termination could not make use of both rights because under the contract, the termination would only have occurred 30 days thereafter, under common law immediately, and this was held to be inconsistent. But, Honourable Tribunal, there is nothing in the present case that would justify to hold that there is an inconsistency between those rights. They can both be used at the same time.
Can I just seek a clarification? Is it your case that your client terminated the charter based on the express provision, or that your client had concurrent rights under common law?
It is not contested that my client also terminated under the contract. What is submitted that the same...
No, sorry, when you say under the contract, you mean clause 2?
Absolutely, Madam Arbitrator.
Right, so if that is... Let me come back to this point of law. There is a distinction, is it not, between a case where a contract is terminated pursuant to an express provision, and one where, and that's the second scenario, where the party had terminated pursuant to an express right as well as a concurrent right under the contract. Because that affects the damages that's recoverable. So it's not a question of election, it's a question of whether there are concurrent rights.
Madam Arbitrator, I understand that you would consider clause 2 as an exclusive remedial regime.
No, clause 2, as read by your opponents, is a cancellation provision. and that under certain events occurring, the charter party can be cancelled.
Yes, Madam Arbitrator, this cancellation clause, if you read it, is not triggered by breach. It just operates if the ship...
So it's a right of cancellation, and therefore that with no remedial rights.
Yes, Madam Arbitrator, yet in the present case there have been repudiatory breaches by the other side.
Right, that's a separate matter, right?
Yes, but that makes a huge difference on the law. Because if there are repudiatory breaches, and I would like to refer in this regard to the case of Gierbalg.
Well, just before we go there, an election is a choice a party is deemed to make by law because he goes for one right or another, each of which is inconsistent. The right to bring the charter party to an end under clause 2 without recourse is inconsistent with the right to sue for damages for the event on which you rely to bring the charter party to an end without recourse. So you can't have both, can you? You've got to elect which one you want to use.
Mr. Chairperson, my client cannot have the cake and eat it, indeed. But
so which cake are you putting forward for us to eat?
The proposition is there are 2 cakes, and they can be eaten at once. There is no inconsistency. There is no inconsistency that is submitted, because there were only 2 cases that they have not even been relied on by my learned friend. There have been 2 cases. I've tried to distinguish on the facts. There is no other authority where it was held that they are inconsistent. This is very much a factual question. It is factual because that depends on what damages can be claimed under the cancellation clause. Now, if there had been, or has been a repudiatory breach, then it was held in Gierbalg that it is wrong to treat the right...
So where is this case?
Okay, you can find this under the yellow K tag in the bright grey folder. Now, so this is the folder that I have given to you.
This one?
Yes, indeed. Mr. Arbitrator.
Which tab?
It's yellow K. It's rather...
Yes.
Yes, you see that. Okay, good.
The Gierbalg.
So it's the Court of Appeal from 2009, and I'm referring to the speech by Lord Justice Moorbeek. And please open page 38. Page 38, and I'm referring to below F, where it says that it is wrong to treat the right to terminate in accordance with the terms of the contract as different in substance from the right to treat the contract as discharged, by reason of repudiation at common law. In those cases where the contract gives a right of termination, they are in effect one and the same. Now this means, for the present case, if there has been a repudiatory breach, those rights are one and the same, unless maybe they are inconsistent, and this is contested by my client for the reasons just given.
But what does the word without recourse, what work do they do if your argument is right that you do have recourse?
Mr. Arbitrator, the first submission made is, and I'm just referring to the next paragraph, paragraph 22, that, and that this is under F, one starts from the presumption that neither party intends to abandon any remedies for its breaches arising by operation of the law, and clear express words must be used in order to rebut this presumption. In addition, it is submitted that an exclusion clause directly, and not as a last resort, needs to be read contra proferentum. This has been held in photo production by the House of Lords. Now, reading this directly, contra proferentum, and bearing in mind that there is a presumption that my client does not intend to abrogate its rights, without recourse needs to be construed very narrowly. Narrowly, and I'm proposing or suggesting 3 possible readings, that it only excludes loss of profit, or that it only excludes the second limb of Hedley and Baxendale. In the very least, maybe no loss of bargain. Yet in the end, there is no inconsistency. There might be a difference in the legal effect, but no inconsistency. I would now like to move to my next submission, that there has been a repudiatory breach. The breach that is alleged by my client is that my learned friend's client renounced its reasonable dispatch obligation. I'm sure that you have heard many times what a renunciation is. And the question is, have they by words or conduct evinced an intention not to perform the contract or be unable to perform the contract in some essential respect? Now, both by conduct and by words have they done so. It is very essential that a party, before the loading port, adheres to its reasonable dispatch obligation. Otherwise, the ship will not make it to the loading port in time and ultimately not in time to the discharge port. Even more so in the present case. Because
what about the exception in clause 19?
The exception in clause 19, it is submitted that the ship has been arrested.
Yes, so if you fall within that, where do they have the resources to pay the bond when you didn't pay the freight?
Mr. Arbitrator, it is submitted that it has been arrested, and if the very close reading, and this is on page 55 of the case facts, and now please all put on your reading glasses because this is a very small print. It just says arrest or restraint of princes, rulers or people, semicolon, or seizure under legal process, provided bond is promptly furnished. Now, promptly furnished bond relates to both. And this is what my Bernard's friend client has not done. They have not put up bond promptly. They knew that there was a strict deadline at the discharge port. They knew they only had 2 days to release the ship from arrest. Yet, they were under no rush to agree to their demands. If I would only have 2 days, I'd be quite in a rush. Now this is
you might not put up a lot more money than you really legally had to, would you?
But, Mr. Arbitrator, is this a risk my client should bear or them? If they don't pay for the bunker, it should be for them to get out of trouble. It shouldn't be for my client to eat their problem or to live up to their problem.
Mr. Dopshire, you said a moment ago that the owners evinced an intention not to perform by their conduct and by their words.
Yes.
You've addressed us on conduct. What are the words that you say evince this intention?
Mr. Arbitrator, I'm very short of time, but I'm of course give you an answer to that, and you can find the answer on page 95 of the bundle. 95 of the bundle of documents, where it says that we, reliable tankers, have not been able to have the reliable butterfly released from arrest. She will not therefore make her Leung. Now this by words means we are not going to perform the contract because we have been unable to release her from arrest. Releasing a ship from arrest only takes a couple of hours at best, and therefore it is submitted that this amounts to a repudiatory breach for which my client has terminated the contract under both common law and the cancellation clause, those two rights being not inconsistent, and therefore my client can ask for loss of bargain damages. In other words, to be put in the position as if the contract had been performed. Now, freight is there used as a measure to confer to my client the benefit it had received. And this is a very reasonable and commercial reading of that case. Thank you very much.
Time is up.
Yes, Mr. Will, you are so.
Members of Tribunal, I have 2 points of rebuttal. The first one concerns the difference between concurrent rights and cancellation under express provision. I believe this was the question made by Mrs. Ang and was further asked by Mr. Rares. We submit that there is a big difference, and it was agreed by our learned friends, because cancellation under termination clause in this contract provides a cancellation without recourse, while if it is cancelled by repudiation, the breaching party is no longer entitled to rely on those clauses. We therefore submit that because of that, election becomes important. The point made by the respondent is that acceptance can come in any form. However, that only applies if the cancellation and repudiation have similar effect. In the present case, it does not, and election becomes important. That is, the election made by the respondent is clear that they would like to cancel without recourse, and that is the effect that the tribunal should give. The second rebuttal concerns the effect of the duty of reasonable dispatch. Members of Tribunal, we would like to establish that the duty of reasonable dispatch has always been a question of facts and not question of law. We submit that in Redland, parties and bunker suppliers usually claim for preposterously high figure, and therefore in that particular case, it was only reasonable for us to try to negotiate directly with the third parties, especially given the fact that the P&I Club does not cover for unpaid bunkers, and it was also caused by the unpaid freight that is intentionally done by the respondent. That concludes my rebuttal.
Thank you. We are very indebted to the counsel for both parties for their excellent arguments, and we will adjourn to consider our decision, which will be announced at dinner tonight. All right, Ms. Mullen. Side for the procedure. 8 minutes. Which one of you is going to do that? You'll do that. Okay. And then the rejoinder you'll do, Ms. Petrova. And then 1 minute. So on the procedural one then, as we understand it, you've agreed 13 minutes for Ms. Petrova, 8 minutes for Farah, and 1 minute in rebuttal for Ms. Petrova. And then the substantive points, are you, Farah, going to spend 6 minutes to begin with on those, and then Mr. Nebrana.
It's Mr. Negrana, is it?
Wirabuana.
Wirabuana.
You're going to spend 14 minutes on the substantive point, and then Mr. Dokstadt, you're going to spend 16 minutes responding, and who's going to do the rebuttal?
I'll be delivering the
You'll do the rebuttal. So, yes, that's clear. And are there any other procedural matters that we need to clear up before we start? How you're going to run the procedural side of the case, and who's going to do what?
Both parties have agreed that the respondent will raise their procedural claim first. It will be responded by the claimant, and then the respondent will have a rejoinder with regard to procedural claims. It will be followed and continued by both counsel for the claimant on the substantive claims, and will be continued by both counsel for the respondent, and then we reserve 2 minutes for rebuttal.
And how have you divided up the time for the procedural points, and how much time is each of you as speakers going to take on those, so that the timekeepers know? And
the respondent will first speak for 13 minutes. The claimant will then speak for 8 minutes. The rejoinder will be 1 minute, and 1 minute, and then the claimant will speak for another 6 minutes. The second counsel for the claimant will speak for 14 minutes, and then
I will continue by speaking for 16 minutes.
And then we will have a rebuttal for 2 minutes.
okay, so that there's going to be one counsel. I take it, Ms. Petrova, it'll be you on the procedural point for 13 minutes.
Correct.
13.
13, yes. And then who will speak? Well, Ms. Petrova, would you like to start with?
Mr. Arbitrators, Madam Arbitrator, good evening. In the upcoming 13 minutes, I will present the procedural arguments on behalf of supercharters. At first, I should establish why we're here today. We are here today because reliable tankers spectacularly failed to fulfill their contractual obligations. Not only did they do that, they also neglected to fulfill the procedural requirements for commencement of arbitration. And now they don't want to live up to the consequences of their mistakes. In light of that, and on behalf of my client, I would make two submissions. The first submission is that reliable tankers' first reference is a nullity and does not validly commence arbitration. This submission is followed by my second submission, that counterclaims by reliable holdings with respect to supercharters' second reference are time barred.
Can we have the formal appearances of the parties, please?
Good evening, members of the tribunal. My name is Farah Nabila, and this is my co-counsel, Mr. Rafaldi Wirabuana. We're representing Reliable Holdings Incorporated, the claimant in the present dispute.
Thank you, Ms. Nagara.
Farah Nabila.
Pardon?
Farah Nabila Nagara.
So, what name do I use to address you?
Farah would be
Fair, yes. Very well, thank you.
Good evening, the arbitrators. My name is Anna Petrova. I appear alongside my colleague Don Dobstad. We represent supercharters, the respondent in these proceedings.
Thank you, Ms. Petrova. Now, have you worked out between you